Greetings and welcome to today's webinar on Medicaid and work requirements in Kentucky, brought to you by the Network for Public Health Law, the National Health Law Program, and the American Society of Law, Medicine, and Ethics. My name is Dave Clark. I'll be your host for today's event. Now, before we get started, there are just a couple of things I'd like you to know about. Concerning the audio, today's webinar is listen only. That means that you can hear us, but we can't hear you. But that doesn't mean that today's event won't be interactive. We'll have a Q&A session at the end of the webinar, and you can type your questions at any time into the Q&A panel. The Q&A panel is located on the right side of your screen. It can be toggled on and off by clicking the Q&A icon that you'll see on the top right of your screen. Or if you're on a Mac today, you'll see that icon on the bottom right of your screen. Now, in the Q&A panel, it's very important that all panelists is selected from the drop-down menu. If it doesn't say all panelists, please make sure to choose that option before typing your question so that your question gets sent to the right place. And by the way, you can also use the Q&A panel to communicate with me. If you're having any technical problems, including audio issues, just let me know what the problem is. We're really interested today in your thoughts and questions, so be sure to get all of your questions into the Q&A panel. Our presenters today will try to answer as many of your questions as they can, I promise. All right, well, let's get started with today's presentation on Medicaid and work requirements in Kentucky, and let's begin by meeting our presenters. Jane Perkins is a senior attorney at the Network for Public Health Law's Southeastern Region Office and the legal director at the National Health Law Program. She specializes in maternal and child health and Affordable Care Act implementation. As I mentioned, she's also the legal director at the National Health Law Program, a public interest law firm working to advance access to quality health care and protect the legal rights of low-income and underserved people. Jane has served as counsel in more than 30 high-profile lawsuits across the country to protect and advance the health rights of low-income and underserved individuals. We'll be hearing from Jane a little later on, but first up today is Sarah Summers, managing attorney at the Network for Public Health Law's Southeastern Region Office and the National Health Law Program. Sarah specializes in litigation and litigation support intended to advance access to quality health care for low-income and other underserved people. Working with health and poverty law advocates across the country, she engages in litigation, research, writing, and training on the Medicaid program, the Americans with Disabilities Act, and the Affordable Care Act, among other issues. In addition to presenting today, Sarah will also serve as our Q&A moderator for this webinar. Sarah's up first today, so Sarah, over to you.
Thank you so much. Thanks for that introduction. And here's some more information about two of the co-sponsors of today's webinar. The Network for Public Health Law protects and promotes the health of communities and advances health equity through the effective use of law and policy. One of the important things to know about the network is that we provide technical assistance on public health legal issues at absolutely no cost. We also have a wonderful newsletter and a multitude of written resources on public health law and policy. Please get more information and come to our Public Health Law Conference in October, and you can join our mailing list to get more information about that. As Dave mentioned earlier, NHELP is a nonprofit that improves health access and quality for low-income and underserved people. We advocate, litigate, educate, and write about public health, Medicaid, and health access issues. We're partners with many state organizations, the disability rights entities in each state that are federally funded, and we have a historic mission of partnering with legal services organizations around the country. You can also join NHELP's mailing list and get more information about the work that we're doing. So, what I'm going to do in the first part of the presentation is I'm going to set up some of the background about the Medicaid program and about the 1115 waiver programs that states are taking advantage of now to use to expand their Medicaid programs. And then I'm going to turn it over to Jane Perkins to talk about the specifics of Kentucky's 1115 waiver and the litigation that has resulted from the federal government's approval of the waiver. As I'm sure many of the people on this call know, Medicaid is the publicly funded health insurance program that's original mission was to cover low-income people. Back in 1965, when it was established as a part of the New Deal, it was for the first time an entitlement to public health coverage. Originally, it was conceived as a program that covered aged, blind, disabled people with disabilities, children, and caretaker relatives. And in years since, it has covered more than just low-income people and has grown to cover other populations as well. Medicaid right now is coming up on serving 75 million people. It's the largest source of health insurance coverage of any kind, and what's more important, and something that a lot of the public was coming to realize during the discussions about Medicaid in the last year, is that it is absolutely the largest source of payment for long-term care. Long-term care is not an area that's traditionally had coverage through the private insurance market, and Medicare has many holes in the coverage of long-term care. So Medicaid is really the safety net in that regard, not just for low-income people, but for middle-income people as well. A key fact about Medicaid is that it's a cooperative state and federal program. Not only it's administered both by the state and federal government, but the funding comes from the state and the federal coffers. For every dollar that is spent on Medicaid services by the state, it's matched by at least $1 from the federal government. The matching rate varies depending on state per capita income, and it settles down at about an average of 58% federal match for this fiscal year. So Medicaid, because it's a cooperative program, it has inherent flexibility. The federal government prescribes sort of the floor or the bare bones of the program, both as far as eligibility, coverage is concerned, the services that are covered, and other aspects of the program. And then the state has a variety of options to make it more generous, to add on to it, or to adapt it. Through a state plan, the state sets forth the blueprint for its Medicaid program. If you've ever seen a Medicaid state plan, it is voluminous and has many additions and many attachments. And there is the basic federal requirements that the states have to adhere to, and then states can, for example, cover additional eligibility categories beyond the very basic categories. They can cover additional services. There are rules that govern provider participation. States have to accept willing providers and provide free choice of providers to those who are enrolled. And there are strict rules governing premiums and cost sharing, because Medicaid is a program for people with limited means and limited ability to pay for their health care. There are protections on how high those, whether premiums can be charged and how high cost sharing can go. As I mentioned, Medicaid was originally covered categories of children, aged, elderly people, people with disabilities, and caretaker relatives. Within those broader categories, there were options for states to be more generous and cover additional people. There is a slate of mandatory services that must be covered, usually sort of the basic bread and butter medical services like hospital services, doctor services, nursing home services. States have the option through their state plans to add on to that as well. So that's just the flexibility within the state Medicaid plan. Medicaid also offers the ability for states to apply for waivers. There are different kinds of waiver programs, and the reason they're called waivers is because states are allowed to waive or ignore certain statutory Medicaid provisions that would otherwise apply to them through their state plans. For example, every state has asked for waivers over the years to provide home and community-based services to people with disabilities or older people. There are also many different options through the waivers to adapt delivery systems. The most common way that, for example, managed care has been offered over the years is through different kinds of waivers. In addition, Medicaid offers the ability to do experimental or demonstration programs. And that leads us to the specifics of what we're talking about today. But first, the Affordable Care Act expanded Medicaid beyond the services that it originally covered back in 1965. Now it enables states to it required states, to extend coverage to citizens between 18 and 64 under 133% of the federal poverty level. This didn't include people on Medicare or women who were pregnant, but for the most part it swept everyone else in, addressing a big hole that had been existing in the federal safety net and in health care coverage. However, despite the fact that that is on the books as a statutory requirement, in 2012, through some of the many lawsuits that were filed challenging the Affordable Care Act, the Supreme Court held that states can't be penalized for not expanding, effectively transforming the statutory mandate into an option. And so as a result, there is unequal coverage around the country, and almost 18 states have yet to adopt the expansion. As a result, not just of the Medicaid expansion, but of the subsidies for coverage through the private insurance market, the uninsured rate plummeted once the Affordable Care Act was passed. And for states that have expanded, it went from a high of 15% in 2013 and was almost cut in half. Just about cut in half to 7.5%. Overall, the United States uninsured rate declined by 6%. Even in non-expansion states, the uninsured rate declined through marketplace coverage, but obviously there's still many opportunities for that to be expanded. Now, during the Obama administration, states had begun to expand their Medicaid programs by using waivers. And what they would do is they would ask for permission to waive other requirements as a part of their Medicaid expansion. For example, they would sometimes ask to waive the requirement to cover non-emergency transportation, or they would ask for permission to impose heightened cost sharing or to impose premiums. In a number of cases, that permission was granted. However, some states asked for permission to impose work requirements as a condition of Medicaid. The Obama administration made clear that that HHS did not consider that consistent with the Medicaid program and wouldn't allow states to do it. They wouldn't give that permission. However, once the administration changed and there was a new leadership at CMS, they announced a new direction, and they made it clear that they were more than open to work requirements as a condition of enrollment in expanded Medicaid. Initially, there was a letter that went out to state Medicaid directors, which is an important way of communicating a change in policy to Medicaid directors, saying that they were going to encourage states to increase employment and community engagement opportunities. Another important purpose of the new administration was to align commercial and Medicaid coverage and ultimately to get people off Medicaid. In an important address to the state Medicaid directors last November, the leader of the Centers for Medicare and Medicaid Services, Seema Verma, spoke in negative terms about expanding Medicaid to able-bodied adults who were part of the traditional Medicaid categories, and announced again, made it clear the intention was to get people off Medicaid and to get them into commercial insurance. And finally, we see the culmination of this kind of philosophy as referring to working as a social determinant of health and announcing a determination to influence that. For example, a number of examples of that is the actual approval of a recent 1115 application from Indiana that we'll talk about later, and framing the need to impose work requirements as an attempt to address the social determinants of health. So I've been talking around this, but what is a demonstration waiver? This code of the section of the Social Security Act, 42 U.S.C. section 1315, authorizes states to provide experimental, pilot, or demonstration projects. They can do this if the Secretary of Health and Human Services finds that it's likely to assist in promoting the objectives of the Medicaid Act. And this enables the HHS Secretary to waive compliance with requirements of Section 1396A of the Medicaid Act. This has all the requirements for state Medicaid plans. And they're allowed to do that to the extent and for the period needed to complete the experiment. So it needs to be an experiment, a pilot, or to demonstrate something, and has to fit within those particular boxes. So what I'm going to do is now leave you to contemplate this slide of what's happened in Kentucky and pass it over to my co-presenter, Jane Perkins.
Thank you, Sarah. So we're going to focus now on what Kentucky has asked for and been given permission to do through the Section 1115 waiver authority. This slide is a timeline of what has occurred in Kentucky to date. We don't need to dwell on it. I think just a couple of points about it are that, as you'll notice, the Kentucky waiver was actually submitted during the Obama administration. It wasn't acted on, and it was one of the carryover waivers that was at CMS when the new administration came in. In the middle of the time frame, I think it's worth pointing out that on January 11th, 2018, the Centers for Medicare and Medicaid Services issued a Dear State Medicaid letter, which they said was announcing a new policy, and one that was allowing work requirements which had not, and community engagement policies which had not previously been allowed. The very next day, on January 12th, the Kentucky Health Waiver was approved. About 2 weeks later, a lawsuit was filed, and then earlier this week, another lawsuit was filed. We'll talk a little bit about that. In the interest of disclosure, the Stewart v. Hargan and Commonwealth of Kentucky v. Stewart, the National Health Law Program is one of the law firms that is representing the plaintiffs in the Stewart v. Hargan case, and yes, it is the same Stewart, the defendant in the Commonwealth of Kentucky v. Stewart case. So the subtitle of the webinar today was, has Kentucky gone too far? We don't know the answer to that yet. That's something that a court will decide, but I will go through some of the issues that have been raised in the Stewart v. I guess it's now Azir case. Just to set the scene, what Kentucky asked for permission to do and was given permission to do was to impose mandatory work requirements, to impose premiums on very low-income people, including someone who has no income, for example. Now, premiums had been previously allowed during the Obama administration. It differs from here. These are restrictive. This is a restrictive waiver approval. The Obama administration approvals were for Medicaid expansion, and they did not go into these low levels of income that this approval does. There's cost sharing for non-emergency use of the emergency room. Individuals are locked out of and terminated from coverage if they don't comply with work requirements or other reporting requirements. This waiver eliminates a feature of Medicaid that is typical, and that is 3 months retroactive coverage. It's a provision which, as you might imagine, is valuable to hospitals that serve low-income people. People will not be on Medicaid, not have coverage. They get in an accident, they go to the hospital. The hospital's going to care for them, and this allows there to be a retroactive coverage of up to 3 months if they would have qualified during that 3-month period. Also, under the Kentucky Health Waiver, there is no coverage of non-emergency medical transportation. As I mentioned, the approval of this waiver has been challenged in federal court in the federal district in the District of Columbia. The case has been filed by 16 plaintiffs. They are a range of incomes. All of them are obviously residents of Kentucky. They have varying work and work statuses. They are students, musicians, morticians, house cleaners, custodians, car repair people. I think if you look at the complaint, you'll see that a surprising number of them are older. They're in their 50s. Some of them are members of our caretakers who couldn't qualify under the traditional or older previous income eligibility cutoffs for caretakers of low-income children, but have qualified through the Medicaid expansion. Notably, Kentucky expanded Medicaid through a state plan amendment, And what this new governor of Kentucky, or what the current governor of Kentucky, Governor Bevin, wants to do is to end Medicaid expansion through a state plan amendment and instead have the expansion occur through Section 1115 waiver authority. That move will, by the state's own estimates, cost upwards of 98,000 people to lose coverage through Medicaid. In this case, the claims against the federal government are really two in primary nature. There's an allegation that the Constitution has been violated. There's a provision in the Constitution that says that the executive will take care to execute the laws that Congress has enacted. The allegation in the complaint is that the administration is not doing that. Instead, it has, in the administration's own words, has sought to explode the Affordable Care Act to fundamentally transform Medicaid and to restructure the Medicaid program, taking aim at Medicaid expansion, which was a part of the Affordable Care Act, as Sarah mentioned, and which the administration has labeled one of the most flawed aspects of the Affordable Care Act. The complaint also includes claims under the Administrative Procedure Act. This is a law that governs the conduct of federal agencies, and it is designed to ensure that their actions are fair and legal. The first claim under the Administrative Procedure Act is that the letter that the administration issued on January 11th, the day before they approved this waiver, should have been subject to provisions in the APA which require there to be an opportunity for public comment, and that is triggered by a notice in the Federal Register that sets the policy forward, gives opportunity for comment, and only then will it impose or finalize a rule. The second aspect of the APA that is at play in this case is the one that, or is a part of the APA that calls for fairness in decision making. So when an agency takes a final action, and the approval of this waiver is, that action can be challenged if it's illegal, if it's ultra-virus, or not in accordance with the law, or if it's arbitrary and capricious because it's not supported by the record. So let's look at some of the aspects of the waiver approval and compare them to the Section 1115 waiver authority. As Sarah mentioned, the authority is limited to the approval of experimental pilot or demonstration projects. Congress has said that a detailed research methodology and comprehensive evaluation are required, and that a simple benefit cut, which might save money but has no research or experimental goal, would not satisfy the requirement. A couple of examples from Kentucky. The approval does not contain metrics, doesn't contain an evaluation, doesn't have clear hypotheses that are and how those are to be evaluated. Rather, that is left for the state to put together. And for many of these things, if the state wants to change them, it doesn't have to come back to the federal government to make that change. So there is, in the complaint, we believe, a lack of a detailed research methodology and comprehensive evaluation, which would be the bedrock needed for the Secretary to approve an experiment. To put it another way, the Secretary would need to know what the experiment is before approving it. There are other aspects of the waiver, other waivers that have been given here that we know that the complaint is arguing have no experimental pilot or demonstration value. An example here would be waiver of 3-month retroactive eligibility, or elimination of non-emergency medical transportation. This is, there's no question what's going to happen when those two things happen. Under the former, people are going to lose benefits. Under the latter, people are going to lose services. They would arguably fall within the category of being a simple benefit cut. Of course, these things are, and I will repeat this and not say it again, but these arguments are just that at this point, and these are things that a court is going to have to decide. Another limit on Section 1115 authority that Sarah mentioned is that the Secretary can only waive provisions of one part of the Medicaid Act, and that's a part called Section 1396A. And when you look at the Medicaid Act, it's a really long title of the Social Security Act, and there are 52 provisions outside of Section 1396A. So there's a lot in the Medicaid Act that the Secretary can't waive. Examples of provisions that are placed outside of 1396A are cost-sharing limits that are described in this particular provision that's cited here, Section 1396OF. It says that under any waiver authority, under any circumstance, including any waiver authority of the Secretary cannot approve co-payments unless they are under tightly controlled hypothetical circumstances with a control group and an experimental group, that it can't last for more than 2 years. There are other circumscribing factors here, 5 of them in total. But the 5 of them in total, I'll just say that the Kentucky waiver was approved for more than a 2-year period. And also limits on premiums. Under the Medicaid Act 1396, this provision here, O-1, which obviously isn't in A, the Congress has said that premiums cannot be imposed on individuals whose incomes are below 150% of the federal poverty level. These things that Congress has done with respect to affordability are not surprising. These affordability features, co-payments, cost-sharing premiums, are the most heavily studied aspect of the Medicaid program. There's 40 years of research into the use of cost-sharing and premiums, and this research is consistent, it's redundant. The research finds that when you impose these cost-sharing or premium limits on low-income people, it causes them to not to enroll in Medicaid or to drop Medicaid coverage or to forego even necessary care. Another aspect of Section 1115 is that it is to promote the objectives of the Medicaid Act. And so just using work requirements as an example here. So the question is, are work requirements likely to promote the objectives of the Medicaid Act? To determine what the objectives are, you just need to look at the Medicaid Act itself. The Medicaid Act, right at the very beginning, says that the purpose is to enable each state to furnish medical assistance on behalf of families and individuals whose income and resources are insufficient to meet the cost of necessary medical services and rehabilitation and other services to help such families and individuals attain or retain capability for independence or self-care. So to boil that down, the purpose of the Medicaid Act is to provide medical assistance. Now, this can be, I'm sure that many of you already know, but the Medicaid is just one title within the Social Security Act. To put it another way, it's one patch of the federal safety net. There are other titles of the Social Security Act. There are other programs that make up the federal safety net, and the purposes of these programs differ from one to the next, from one to the other. While the purpose of Medicaid is to provide medical assistance, you can compare this to what Congress has said the purpose of temporary assistance to needy families is. TANF is what used to be called AFDC. I guess you could call it welfare. It's benefits. It's public benefits, cash benefits that are paid to low-income people. And according to Congress, the purpose of TANF is to increase the flexibility of states to provide assistance to needy families so that children can be cared for in their own homes, and to end the dependence of needy parents on government benefits by promoting job preparation, work, and marriage. There are other purposes stated in this law by Congress, but the second one is significant because Congress has expressed the intent here of this part of the social safety net to promote work in contrast to Medicaid, which is to furnish medical assistance. So that is just a thumbnail sketch of the issues in Kentucky and the lawsuit that has been raised or has been filed about the Kentucky waiver. I would just say if you want to know more about that case or about Section 1115 in general, I'm going to go back up here and just show you. So a number of slides in this slide deck have this marked down in the lower right column. And what that means is that NHELP has the National Health Law Program has a publication or a document that goes into greater depth on the subject matter of this particular slide. There's a lot going on with Section 1115, and putting it in a slide just obviously cannot give all the information that a person might need or want to have. So let me mention a little bit as well about the lawsuit that was filed earlier this week. So as mentioned, Mr. Stewart and 15 other plaintiffs filed suit against federal authorities under the APA, which concerns final agency actions and their legality, and under the Take Care Clause, which concerns the whether the federal executive branch is implementing the laws as Congress intends. This lawsuit, Kentucky versus Stewart, just once again, the lawsuit was filed in the District of Columbia, the Stewart v. Azar. We didn't know which judge we would get. There are like 9 judges in D.C. and 4 or 5 senior judges, and it's a random assignment. This lawsuit was filed by the governor against the 16 plaintiffs in Kentucky. It's interesting because it's filed for a particular docket in a particular division in a particular district in Kentucky. That's all legal talk, but what it boils down to is there's one judge in that, that there's only one judge that this case could be assigned to. So that's, some people would question whether that was forum shopping. The case seeks declaratory relief against the 16 low-income state residents that the waiver is illegal. I'm not sure how that claim can be redressed or how it can be traced to these 17 people or 16 people. They are kind of exercising their right to, under the First Amendment and other laws, to challenge actions in court. But that, nevertheless, is what this case does. It is mirroring the Stewart v. Azar case in that it concerns the APA and the constitutional claims. There's no new claims in the case, in other words. So where this sits right now is that Kentucky taxpayer money is being used by the governor to sue citizens of his own state to get a declaration that something which, as we sit here today, is legal, is legal. That's probably all I should say about that. To go to the next slide, the work requirements, these premiums, the types of waivers that the federal government gave or approved in Kentucky are not unique. And that's what this slide shows. You can see that there are a healthy handful of states that are have either just been given in the instance of Indiana or have pending requests to be given permission to do many of the same things that Kentucky has been given permission to do. A few things that are a bit different about some of these, just to keep your eye on. If you look at drug screening, Wisconsin has as a condition of Medicaid eligibility that individuals submit to mandatory drug screening, testing, and treatment. And if they don't do that, they don't get any, not just that they don't get any Medicaid benefits. Those of you who are familiar with drug screening programs and other programs know the research on these shows them to be highly cost inefficient. And then a couple of states are placing limits on how long you can be enrolled in Medicaid. In other words, there would, in Arizona, for example, there's once you hit that limit, you're not eligible for Medicaid anymore. So you could have a change in circumstances, but you wouldn't be eligible for Medicaid because you would have hit your limit. So that just there's lots going on in this chart, and I would just commend it to you to pay attention to. We've been focusing on work requirements a little bit more here today, so just wanted to conclude with this this slide and just question whether this work requirement is a solution in search of a problem. If you look at the 10 states that are seeking to impose mandatory work requirements, it's clear that the vast majority of people either already are working or they can't work. So you have a very small percentage of Medicaid beneficiaries that this is aimed at. These programs are going to cost millions of dollars. I think I saw in one state $47 million, something to that effect. And so a question whether that is an efficient use of Medicaid money, whether using Medicaid funds in that way is consistent with Medicaid's objective, which is to, as far as practicable, furnish medical assistance. So as we move forward, obviously there's many questions to consider in terms of these waivers. They really mark a sea change. Section 1115 waiver authority has not been used in this way to implement restrictive programs. Medicaid waivers in the past have been used to expand Medicaid to ensure quick, accessible, and ready relief during a national emergency, whether it be 9/11 or Hurricane Katrina. They have been used to experiment with delivery system design, whether it be integrated delivery systems or back in the early 1980s, capitated Medicaid managed care. Those capitated Medicaid managed care in Medicaid began as Section 1115 projects in 4 or 5 states, and then in the 1980s, the Medicaid Act was amended to allow states to have more flexibility in including capitated managed care as a common feature of a state plan. In other words, not having to go get a waiver to do Medicaid, to do managed care in Medicaid. So the questions are some of the questions are, how do these proposals further the objectives of the Medicaid Act? How are they going to affect low-income people? How do they affect healthcare providers who serve low-income people? Given that Medicaid expansion has been associated with economic benefit, not only in the health sector, but through job creation outside of the health sector, how will they affect state and local economies? How is it going to affect the state's administrative burden, and how is that going to affect access? And is it appropriate to characterize work requirements as a social determinant of health? So with that, I'm going to hand it back to Dave.
Actually, why don't we bring Sarah back on the line? Sarah's going to serve as our moderator for the Q&A session today. Sarah?
Oh, all righty. So we've already got some good questions. First of all, the first question was asking for citations for research on the effects of cost-sharing requirements on Medicaid enrollment, and asking whether there's any research on how those requirements actually increase state costs for medical services. Well, first of all, we have a publication branded by the National Health Law Program, catchily titled Medicaid Premiums and Cost-Sharing. It's written by Jane Perkins and our policy analyst, David Mocklet. And it came out in 2014, and it was a collection of the research at that point on the impact of Medicaid premiums and cost sharings, and there are quite a bit of citations in there. We can make that available, I think, somehow through the magic of the Internet. Dave, maybe you could help us with that. But you could also just Google Medicaid premiums, cost sharing, Jane Perkins, and help and find it. Jane, do you want to speak to any more recent research or the research on increasing state costs?
I would just say that the Kaiser Family Foundation has issued a report since our report that pulls in the more recent research. Both that work and our report do talk about some of the cost implications of cost sharing and premiums.
Yes. So another question came in as to what other public programs require work. As Jane discussed, TANF, the Temporary Assistance to Needy Families, sort of inherent in the statutory makeup of that program is a work requirement. I know there are also work requirement options connected with SNAP, which is the nutrition assistance, what used to be known as food stamps. Jane, I don't believe WIC does. Jane, do you know of others?
I know that that's the ones we're focusing on because there's good, well, not only is there express statutory authorization, but there's a good track record of study that shows how work requirements in those programs work. I will say that one of the things that the administration is interested in doing is imposing work requirements not only in Medicaid, but also in public housing benefits. One of the things that, and not just to run off the rail here, but I think it's important to contrast where Medicaid has come from where Medicaid could go. In the early 1980s, Congress began to unlink Medicaid from welfare. Previously, as Sarah pointed out, it had been tied to receipt of public assistance like AFDC or SSI, Supplemental Security Income. So not only did you need to be low income, but you needed to fit within a category. Some people called it, you had to be among the worthy poor. You couldn't just be poor. You had to be poor and disabled, or poor and older, poor and a child. that began to be unlinked in the 1980s, and that really culminated in 2010 with enactment of the Medicaid expansion in the Affordable Care Act. Interestingly, about 18 states had already done this type of expansion using the Section 1115 experimental authority, and we're finding that you could, I don't think all states actually implemented the authority that they were given, but in other states they were able to expand Medicaid to everyone under a certain percentage of poverty using benefit delivery system reforms and other features, and able to operate Medicaid programs that were and continue to be more efficient administratively than commercial insurance, for example. So by the time we got to last year, when the Affordable Care Act's future was being debated, I think many of us remember the role of Medicaid there in that debate, and real recognition that Medicaid is a source of health insurance and a part of the comprehensive health insurance system that the Affordable Care Act was seeking to obtain. What the Dear Medicaid letter from January 11th, the statements of the administration and the approval in Kentucky do is to kind of once again target certain poor people for target their access to health insurance by either labeling them able-bodied or really focusing on the policy belief that the Affordable Care Act was flawed in many ways, including by seeking this Medicaid expansion. Sorry to digress there, but anyway.
Mm-hmm. So there's another question as well. For the cost-sharing requirement for non-emergent use of the emergency department, does Kentucky say who makes that decision? Jane, do you know the answer to that? And I can also follow up with more broad discussions of some of the other states.
I do, but I can't remember it. Sorry.
Well, I think in general, this leads to sort of a broader point you can make. There are some details like this that are spelled out in the waiver itself and what the federal government calls the special terms and conditions. And there are sometimes details like this are spelled out and sometimes they're not. I am more familiar with Indiana's application and approval, and details like that are defined by reference to state regulations that define emergency or non-emergency, sometimes in the Medicaid context and sometimes in like a broader, emergency medical treatment, the anti-dumping patient anti-dumping law. And so it'll be done by reference to the state regulations. Also, some important aspects, to do with exceptions or exemptions are defined by the managed care plans that administer the program. But I believe the emergent definition is one that's made by reference to regulations in most of the states.
One thing as Sarah was talking, I do think it's worth mentioning the Maine waiver application. What Maine has done, which is different from what Sarah is describing, is to append an appendix to their waiver, and it lists I don't know how many, 55, 60 different conditions that if the ultimate diagnosis is that the individual came in for one of those conditions, then it isn't an emergency. Now, those of you who work in this area are saying, gosh, what does that do to the prudent layperson standard? And I think that is the question here.
Mm-hmm.
The prudent layperson standard being the federal law in Medicaid that says that you determine whether something is to be an emergency by whether a prudent layperson would have thought they were in an emergency at the time they went to the hospital. It's a feed over from the Emergency Medical Treatment and Active Labor Act, EMTALA.
There isn't another question in the queue, so please feel free to jump in with a question. In the meantime, I will make some broader comments here. One of the things that, to me as somebody who's paid close attention to Medicaid and to the Medicaid expansion, there was a phrase that was commonly used to talk about the expansion, and that was, this extends it to childless, able-bodied adults. And that is, I think, a misconception that merely because you do not qualify for disability under a Social Security program like SSI or SSDI, that you are, quote, able-bodied. And merely because you have not hit the magic age of 65, that you are not, experiencing the impacts of aging. That's particularly true for people who have had more heavy labor jobs, who have had lower incomes all their lives. They may be experiencing the impact of aging at a younger age than someone who sat at a desk for many years. So that sort of got out there into the zeitgeist that these are able-bodied people. And then following up on that, you had the idea that you have a clash of philosophies, a fundamental clash of philosophies, which is the one between the belief that government should be providing a means of providing health insurance, that publicly funded health insurance is a public good, as opposed to the philosophy that government should be as limited as possible and that these types of programs should really only be for people who cannot be served by the private insurance market and who really are in very dire straits. So you have these things going on out there. And so there's the political idea that this is a giveaway to people who don't deserve it, to people who are just sitting around not working. Now, Ohio has recently released their 1115 application, and frankly, I don't recall if it was in the application or if it was in public remarks connected to it, but it was saying, probably 95% of the people are either going to be exempt from or actually be meeting the work requirement, which sort of raises the question, if this is such a big problem, if it's only 5% of the people, why are you creating this program to chase down that 5%? And as Jane mentioned, these are extremely expensive programs. Well, what really ends up happening, and we saw this, there's a track record of this with Indiana. There was a study that came out about the time their waiver renewal was approved, that there are, tens of thousands of people who qualify and who either are exempt from or meet the requirements but get kicked off anyway because of the difficulties of administering a complicated program like that. So, these are the things that are going on out there. Meanwhile, I see another question. Why do you think Wisconsin is the only state with a drug testing requirement for Medicaid? Why not more, and why did Wisconsin do it? Now, I don't know the answer to that question. Jane, do you?
Wisconsin is the only state so far that has proposed mandatory drug tests. I think that one reason that other states have not is because a number of courts in the context of other public benefits have found them to be unconstitutional. It's their Fourth Amendment to the Constitution comes into play here. So I think that's probably why there hasn't been uptake. In terms of why Wisconsin did it, boy, that's one of the ones of stepping into the mind of that governor. I know that he wanted to do it broadly across programs, and probably when the new administration came in, he saw the opening to do it. Some states had, Wisconsin had kind of flirted and maybe more with the idea previously. Maybe Utah had, but didn't get the green light in their discussions with federal authorities, but obviously has gotten that now, or thinks that they could get that. Let me put it that way.
Let's see. Okay, there was another question that came in. How does the regulation affect FQHCs, or does it? I'm not sure what you mean by the regulation, so if you want to type a clarification in the box, I'll go on to the next question and come back to yours. Here's a question. GAO released a report on the challenges in demonstration evaluations and their usefulness in policy discussions. Do you see this as something that's potentially open to legal challenge? That is, if state-led evaluations are not in keeping with the authority.
So I do think that there's two ways to, in terms of the law, there's sort of two levels here. There's the facial challenge level, that is on the face of what has just happened, does it arguably violate the law? And that's what the Kentucky challenge is. The other way to look at this is in terms of what a state is doing with a waiver, or without a waiver for that matter. Are they implementing their approved Medicaid program in a way that is consistent with the approval or with what they've been given permission to do? And if a state isn't doing that, then yes, they're going to open themselves up to challenges. Yeah, yeah, I'll leave it at that.
Yeah. So here's another interesting law question. What happens if there's a conflict in the decisions from the D.C. Circuit and in the Kentucky case? Okay, so I'm going to start, I'll start saying something about that, and Jane, I'm sure, will want to say something as well. Basically, the D.C. decision, the case that's filed in D.C. Court is asking for a declaration that this waiver approval that the federal government has made is not, violates 1115. It hasn't complied with the requirements of a demonstration, pilot, or experiment, and it would be a decision that binds the federal government. And it also raises questions about the validity of the state Medicaid director letter that set out the policy about work requirements. The Kentucky case is, we're trying not to pontificate because obviously we have opinions about that one, but it's hard to know what the impact of that would be, assuming it's a viable lawsuit, because it is a suit by the state against individuals who have no authority or power to do anything about the waiver. And it's essentially asking a court to declare that a waiver made by the federal government is legal when the federal government isn't a party to it. So I have a hard time really imagining how that would even work.
It would be like legislators, after they pass a bill, going to court to have the court say that what they just did is legal.
That's a good analogy.
Keeping in mind, just really quickly, I know we're coming to the end of our time here, but the Kentucky case, there will be a response to that, and it will be a motion to dismiss it, I think, probably. But in the D.C. case, the federal government has made a motion to transfer, and coincidentally, the motion seeks to transfer the case to the same docket to the same state, on the same docket, in the same division, in the same district as the Kentucky case, the place where there's that one judge. And so we are responding to that motion to transfer now. That response is due tomorrow. So those are preliminary questions. That'll sort of where this moves forward. That's going to be a preliminary matter in a way before we get to the merits. So that conflict will be resolved sooner rather than later.
Yes. Okay. Let's see. There's a thought on a question. What are your thoughts on FQHCs and Medicaid? I don't know if this question means with regard to this particular 1115 approval. If so, I think there has already been discussion about how and whether this would place a burden on managed care plans that operate in the Medicaid world in these states, and the extent to which they have to deal with verifying and and making determinations about, for example, whether you satisfy an exemption. I don't know what kind of duties might fall to the FQHCs, but I think, I imagine that depends on, the extent to which FQHCs are doing eligibility determinations. I don't think that that this would affect. Well, I don't know. I'm just going to say it has the potential to burden it. Yeah.
Yeah, and I think as well, too, on by Kentucky's own estimates, upwards of 98 or 100,000 people are going to lose Medicaid coverage. That's because they are going to fail to do something or not meet one of these requirements that's now in place. Some of them will move, if the work requirements were upheld, some of them will get work, but the data from other programs shows that the work that they're getting isn't work that has health insurance. So many of the people who are going to lose coverage are going to become uninsured. They're going to rely upon FQHCs. So FQHCs, which in expansion states have seen payments through Medicaid rise, are going to see that affected because they're going to be now treating people who won't have Medicaid coverage and they won't have private insurance coverage. They're going to be uninsured.
Okay, I think that our time is up, right, Dave?
Indeed it is, and I want to thank both of you for your insights into today's topic. A few final notes. Today's webinar was recorded, and you'll be receiving an email with a link to access that recording when it's available, so check your inboxes for that. There's also a URL on your screen right now that you can visit to access the recording when it's ready. That email you'll receive will also include a link to a brief survey that we hope you'll take. We'd really like to know your thoughts concerning today's webinar and what topics you'd be interested in for future webinars. And finally, you'll also be receiving an email from ASLME with information about applying for CLE credit for this webinar. Again, Jane, Sarah, thanks so much for your presentations today, and thanks to all of you for being with us today. That does conclude today's webinar. Have a great day.